Our next speaker is Matt Prewitt, and he's from Schiff Hardin in Chicago. Matt represents companies in litigation for the protection of intellectual capital and customer relationships, including cases involving trade secrets and post-employment restrictions. He also practices in the environmental and toxic torts area, including the defense of related fraudulent transfer and veil-piercing claims, as well as creditors' remedies under the Bankruptcy Code. Here to talk about controlling risk in trade secret litigation is the undisputed holder of the award for the best mustache in the network. I give you Matt Prewitt.
Thank you. We just heard a very entertaining presentation about what happens in the courtroom, and I'd like to shift attention now to another challenging aspect of being a trial lawyer, which is the relationship between the client and the attorney in maintaining the effective communication about risk and about risk management throughout the litigation, which is, in terms of the success that you achieve in the courtroom, can be just as important or sometimes more important than the cross-examination outline that you prepare or the opening statement or voir dire. I've chosen for this context to look at trade secret litigation because from the plaintiff's perspective, managing that effective communication between attorney and client, whether it's the relationship between in-house counsel and the client's business team, or between the company and outside counsel, when the company is in plaintiff's side trade secrets litigation, the inherent dynamic of that litigation subjects that relationship to a great deal of stress. And so it can be a pressure cooker, and it can be a great place to look for lessons about how to manage that communication. A trade secret suit can be a powerful weapon, and just to sort of put everyone in context here, the plaintiff has a great arsenal at its disposal when it brings a trade secrets case. It can win temporary injunctive relief, a TRO or preliminary injunction. It can impose on the defendant very burdensome and disruptive discovery. It carries the threat for the defendant of potentially crippling damages that can be measured either as the plaintiff's loss or the defendant's profit. There's the risk of punitive damages, and there's the risk of attorney's fees. When you combine these powerful weapons with the tension and stress that comes with trade secret litigation and the high emotion, the mindset that often I hear as a trade secrets litigator on the plaintiff's side when I talk to my clients, we quickly slip into the military metaphor. And so that's the metaphor that we're going to use in this discussion to explore that dialogue. Now, why do we end up in that military metaphor? Well, it's because in a trade secrets context, you have first a business team that feels like the business is being threatened by a competitor who is engaged in conduct that is inherently dishonest. I mean, a trade secrets case is about stealing trade secrets. And more often than not, the allegations in a trade secrets case are going to be based on either an employee who was previously trusted, who turned out to be, from the business team's perspective, a traitor to the company and engaged in outright dishonesty, or a competitor who's used some other sort of subterfuge or dirty tricks in order to obtain the company's crown jewel trade secrets. So the business team feels threatened. They feel threatened by somebody who's using dirty, underhanded tactics. They recognize the high stakes, and they want a lawyer who's going to fight back. When they call you up, although this is a commercial dispute, they're not going to describe the adversary as somebody who's just an ordinary commercial adversary. When you have your initial call with the client, they're going to use the language of an arch villain, arch fiend, someone like the former dictator of Iraq. And they're going to demand an immediate attack. I've put the red telephone up there. for a couple of reasons. One, the trade secrets case comes with a sense of urgency and a demand for immediate action. And then two, there may be a multitude of people who are calling you from the client's perspective, or from the client's side. And part of the trade secret lawyer's challenge is to manage the flow of information to avoid confusion and to avoid miscommunication. The client is going to imagine that they can come in and achieve a victory quickly through a display of overwhelming force. And they want a lawyer who matches the tone of aggression that they want to see in the courtroom. They're going to want somebody who sounds like this and not someone who sounds like this. Someone who drives this to the office and not this. So, from the trial lawyer's perspective, this creates a very difficult dynamic because you want to maintain credibility with your client. You want them to understand that you get it and that you understand the threat to the business, the need to respond aggressively and decisively and to wage war against the adversary. But at the same time, both outside and in-house counsel have an obligation to explore the risks of the trade secret suit. What are those risks? The risk that in the rush to develop the case quickly, essential evidence may be overlooked, evidence that may come back very quickly to have the case explode in the plaintiff's face. The risk that the plaintiff's vision of strong offensive discovery may suddenly flip with the defendant who is demanding deep, probing discovery of the plaintiff's business and the plaintiff's operations. And then, of course, there's the risk that if the case goes really far south, of an award of fee shifting by the court. The Uniform Trade Secrets Act is adopted by almost all states in the U.S. now, New York being one notable exception. Includes Section 4, and as I say, most states have adopted Section 4, and it includes the risk of fee shifting. If a claim of misappropriation of trade secrets is made by a plaintiff in bad faith, the court may award reasonable attorney's fees to the prevailing defendant. Section 4 of the Trade Secrets Act is actually, for the practitioner, a gift, because it's the opening that you need as either outside or in-house counsel in order to approach the client, get the client focused on the risk of proceeding with the trade secrets case, get the client focused on the need to do a careful and thorough development of the case before rushing into court, and to have that dialogue in a way that avoids sounding like you're a pacifist or you're afraid of bringing the case, but instead simply keeping an eye out for the company's risk and protecting the company from a potential counterclaim. Now, unfortunately, there's not much case law on Section 4. Essential questions like when do you measure the decision to bring a trade secrets case? Is bad faith measured only from the perspective of what the plaintiff knew at the time the plaintiff commenced suit? Is it a continuing inquiry so that the plaintiff has to continually reassess whether its case is supported by sufficient evidence? What does bad faith mean? Is it objective or subjective? What discovery is the defendant entitled to in order to explore bad faith? In most U.S. jurisdictions, there are no answers to these questions. And the reason for that is pretty simple. When a case gets to the point where a defendant has a viable, solid claim for fees under Section 4, it's very likely that the plaintiff is running for the door and is eager to get out of the case. And therefore, there are very few instances where you actually have the opportunity for a case to reach final judgment on this issue, even in the trial court, much less produce an appellate decision. And that actually happened in one case that I handled. I mean, we were fortunate enough to win on the defendant's side a fee-shifting award. The trial court had to write that opinion without the guidance of any appellate authority from, this was in Illinois. And then, of course, as soon as the decision issued, the case settled. So, and that is even in those few instances where there is a decision in the trial court, the likelihood that it will produce appellate precedent is very remote. So how do you manage the risk under Section 4 and to protect your client from the possibility of a bad faith counterclaim? Well, the first item is to counsel the client about the risk of fee shifting. Sensitize the business team especially to the possibility that there is downside in bringing the trade secret suit and that there is the possibility of blowback. That first communication lays the groundwork then to have a discussion, a candid discussion with the client about the weaknesses in the client's claim and to motivate the business team to shift them from being advocates simply to pursue litigation without regard to risk to taking a more thoughtful approach with you to explore those issues. Something that is often overlooked by trial counsel, in part because of the fast pace of a trade secrets case, document the pre-suit investigation. There should be somewhere in the counsel's file a log of what witnesses were interviewed before the case was brought, what documents were reviewed. There should be some sort of memo that captures what information was available to the company and what information was considered in the decision to commit suit. And ideally, there should be a document that captures that information that, if push comes to shove, can be made available to the court or to opposing counsel through a limited waiver of the privilege. Having that, when parties enter into trade secrets litigation, there's often this thought, oh, well, it'll be over in 2 or 3 weeks, or it'll be over in a month because we'll win the temporary injunction or we'll win the preliminary injunction. Don't lose sight of the fact that 2, 3, 4 years down the road, somebody may be second-guessing the decision to commence the suit. And 3 years down the road, you may not have a clear recollection of what information was available to the client or to you at the time the decision to commence suit was made. So maintaining that file can be very important. Next, counsel the client on managing internal and external communications. This is where the dialogue of warfare and combat can really get the client in trouble. There's nothing worse than having to defend a plaintiff against a bad faith claim when you have a dozen memos that talk about from the CEO to the general counsel, and yes, waivers of privilege do happen sometimes, inadvertently or through court order, that describe how your client wants to use the suit to crush the competition or destroy them or bury them under a torrent of litigation. Now, we all know that those are maybe sentiments that the client may express, but it's very important to counsel the client to keep those communications out of writing, if at all possible. And then finally, in terms of managing risk, be cautious when setting forth the plaintiff's case in the motion for the temporary restraining order or in the motion for a preliminary injunction. The typical trade secrets case will begin with some sort of motion for interim relief filed with the court that will have to be supported by some type of affidavit. Realize that the person who signs that affidavit is an important spokesperson for your client, and you need to protect that spokesperson's credibility at all costs. Don't take unnecessary risks with the affidavit. Be careful with what you're having the person attest to, and realize the possibility that affidavit may later be used to attack the honesty or integrity of the affiant or the good faith in which the suit was brought. And, again, to go back to our military metaphor, remember that there are very highly credible spokespeople for the plaintiff or for the client. Don't send them out there to attest to the evidence of what's going on behind closed doors or in your adversary's bunkers unless you're quite sure that you're going to be able to back that up. Next, keep in mind that winning the TRO may be only the beginning of the litigation. Oftentimes, on the plaintiff's side, you win the TRO, you win the preliminary injunction, there's a tendency to gear down and to reduce your focus on the case. But the case can shift very quickly. Optics can shift very quickly. And the case that you thought you were winning may turn on you in a moment. And so it's critical for the trial counsel to maintain an ongoing dialogue with the client, continually reassessing the strength and weaknesses of the case and how the case is changing. Keep in mind that the adversary that you thought was a villain when you brought suit is going to have skilled trial counsel as well. And the optics for the trial judge may change very quickly. And finally, remember the value of getting out as soon as you can. If you're a plaintiff in a trade secrets case, that means that you've brought the trade secret suit in order to achieve a business objective. Always keep in focus what that business objective is, and once you've achieved it or come close to achieving it, your focus should turn to bringing the litigation to an end. To summarize, as a trial lawyer in a trade secrets case, it's tempting to view yourself as the conquering hero who's out to annihilate the opposition. But we're not conquering heroes. We're commercial litigators, we're business lawyers, and our job is to achieve a reasonable business outcome. As long as trial counsel maintains focus on that goal and helps the client and the client's business team maintain the focus on achieving a realistic business outcome and realistic business goals, then the client and counsel can maintain a healthy perspective on managing the litigation risk. Thank you.